Good morning, all. Today we will discuss the topic of subject of international law and the place of individual in the international law. सब्जेक्ट जिसे हिंदी में विषय वस्तु कहा जाता है, यानी कि इंटरनेशनल लॉ का सब्जेक्ट क्या है, इंटरनेशनल लॉ किस पर एप्लीकेबल होता है, और इन अदर वर्डिंग वी कैन से दैट इंटरनेशनल लॉ किस पर राइट कन्फर करता है या ड्यूटीज इम्पोज करता है, जिस भी अदर पर्सन और ऑर्गेनाइजेशन और इंडिविजुअल पर ये राइट कन्फर्म करता है इंटरनेशनल लॉ या ड्यूटी इम्पोज करता है, दैट आर कॉल्ड द सब्जेक्ट मैटर ऑफ द subjects of the international law. And we will also see the place of individual in international law. It means what rights are provided to an individual at the international law and what the liabilities are imposed on him. This is the relevant topic for LLB and LLM classes, and also for NET and other examination, which international law, public international law is one of the subject. Now, I have already told what is the subject. Subjects of international law. Earlier, it was stated that only state is the subject of international law. As you just recall the definition of Oppenheim, which we discussed in the first lecture, that Oppenheim firstly said that only state are the subject of international law, but later on he amended his definitions in the 9th edition of his book in 1993. Earlier definition he gave in 1905, and in 1993 he amended his definition. Oppenheim included the individual also in that. Now the other subject of international law is international organizations. Now we are just seeing the various theory regarding the subject of international law. There are three theories. First is real theory, then fiction. It is fictional theory, which is fictional बना है fiction से. Next है functional theory. Let us discuss these theory in detail. Firstly, real theory. As per the real theory, only state are the subject matter of the international law. Some jurists are of the opinion that only state are the subject matter of international law. Like Percy E. Corbett or Oppenheim in his earlier definitions. According to Percy E. Corbett, the trim, that is a lot of development of positivism in the late 18th century, made individual an object and not a subject of international law. ठीक है, पर्से ई कॉर्बेट जो इस थ्योरी को सपोर्ट करते थे वो कहते हैं कि 18th सेंचुरी के लेटर पार्ट में इंडिविजुअल सिर्फ ऑब्जेक्ट था, सब्जेक्ट नहीं था. उन्होंने इंडिविजुअल को सब्जेक्ट मानने से क्लियर कर डिनाई कर लिया, एंड नॉट द सब्जेक्ट ऑफ इंटरनेशनल लॉ, एंड सब्जेक्ट वाज ओनली द स्टेट. सो दिस थ्योरी वाज क्रिटिसाइज्ड and critics only say that the propounder of this theory forget about pirates and slaves. As we know that piracy is an international offense, every state has the right to prosecute that offense. And on the other hand, slaves are the person who has no right but only duties. So this theory, real theory, lacking on the point of pirates and slaves. One writer is such Wurzenbach. He stated that he's surprised to know that individuals are not considered as a subject of international law because society existence are due to individuals only. So according to whom their individual must be as a subject. Next theory is fictional theory, and as the name suggests, it is only fiction. ये कहता है कि जो ये theory है ये सिर्फ fiction है. Individual only, actual में only individual are the subject matter of international law. And Kelsen, K-E-L-S-O-N, Kelsen is the chief exponent of this theory. He observed that state is an artificial person. State artificial है. Existing of state without individual is not possible. State क्या है? अकॉर्डिंग टू मतलब स्टेट इज अ एसोसिएशन ऑफ इंडिविजुअल। जब भी स्टेट की बात करेंगे तो ये कहते हैं, केल्सन का कहना था, वो स्टेट कोई अलग थोड़ी है, वो तो इंडिविजुअल से मिलके बनी है। ओके, नेक्स्ट we will discuss about fictional theory. As per fictional theory, I have discussed that only individual are the subject matter of international law. This theory also have some criticism. Critics says that municipal law directly apply to state, but international law indirectly applies. In actual practice, states are the subject of international law because rights and duties of individual are conferred by the states. And specifically, Philip C. Jessup, एक jurist हुए हैं, he has aptly remarked that, but while I agree that states are not only the subject of international law, I do not go to other extreme and say that individual are the only subjects. तो ये भी मानते हैं कि सिर्फ स्टेट सब्जेक्ट नहीं है। ऑन द अदर हैंड ये भी कहते हैं कि इंडिविजुअल भी ओनली सब्जेक्ट्स नहीं है इंटरनेशनल लॉ के। इट मींस देयर आर मोर देन state or individual are the subject matter of these. So in conclusion of this theory, I can say that the extreme view that individual alone are the subject matter of international law can't be accepted. Individuals are recognized as the subject of international law, and they can now even claim their right against states. But their procedural capacity to enforce their right is grossly deficient. In practice, international law for its major parts still deal with the rights and duties of the states. Therefore, it could be absurd to contend that states are not only the subject of the international law, but actual position is that besides states, individual, public international organization, and some non-state entities are also subject of international law. And other theory, this is functional theory. Function से बना actual functional में क्या क्या है? This is the combination of above two theories, and but this theory goes a step ahead to include the international organization and certain other known state entities as a subject matter of international law. ये इंटरनेशनल ऑर्गेनाइजेशन को भी इंक्लूड करते हैं, ये नॉन एंटिटीज को भी एज ए सब्जेक्ट मैटर इंक्लूड करते हैं. In present, certain treaties have conferred upon the individual certain rights and duties. For example, we can say international covenants on human rights and 1965 convention on the settlement of investment disputes between the state and the nation of other state deserve a special mention in this connection. A landmark case was there. It is Danjing Railway official case, DANZING, Danjing Railways official case, PCIJ. PCIJ stand for Permanent Court of International Justice. PCIJ की ये जजमेंट है 1928 की, सीरीज बी है, नंबर 15 पे. The Permanent Court of Justice ruled that if in any treaty the intention of the party is to confer the certain right upon some individual, then international will recognize such right and will enforce them. ट्रीटी की इंटेंशन देखी जाएगी, अगर ट्रीटीज कन्फर कर रही है राइट इंडिविजुअल पे तो वो राइट इन्फोर्स किए जाएंगे regard to international law. Okay, next example is 1949 Geneva Conventions on the prison of war. has conferred certain rights on the prisoner of wars. These rights have been mentioned in chapter on laws of land warfare. इसके रेफरेंस में मैं आपको और याद दिलवाना चाहूंगी कि देखो अभी अभी जो जिनेवा कन्वेंशन की वजह से ही हम विंग कमांडर अभिनंदन को वापस लेके आ पाए थे, क्योंकि जो हमारे सोल्जर लड़ाई के बीच वहां प्रिजन में डाल दिए जाते हैं, बंदी बना लिए जाते हैं उनको, उनको इस तरह जिनेवा कन्वेंशन के अंदर वापस लाया जा सकता है, और इसी का यूज करके हम अभिनंदन को इंडिया वापस ले सका था पाकिस्तान से। नेक्स्ट देखो, इन एडिशन टू टू एग्जाम्पल विच आई हैव डिस्कस्ड बिफोर, the other example is on human rights is European Convention on Human Rights in 1950. In this, some rights have been conferred against the state upon the individual. और इसमें आपका यूरोपियन कमीशन भी है एंड यूरोपियन कोर्ट्स ऑफ ह्यूमन राइट भी है। पार्टीज अपने एग्रीमेंट के अकॉर्डिंग चाहें तो यूरोपियन कोर्ट से डिसाइड करवा सकती है मैटर। And it is now generally agreed that international organizations are also the part of international law. Next we have place of individual in international law. अब as you know, अब आप सभी को पता है कि इंटरनेशनल इंडिविजुअल जो सब्जेक्ट मैटर है एक इंटरनेशनल लॉ का, और इस पे भी कुछ राइट कन्फर्म किए गए हैं और कुछ ड्यूटी इन पे इम्पोज की गई हैं। लेट अस सी अबाउट दोज राइट एंड ड्यूटीज। राइट्स नंबर 1, ह्यूमन राइट्स। थोड़ा सा इससे मैं आपको इंट्रोडक्शन देना चाहूंगी। प्लेस ऑफ इंडिविजुअल इन इंटरनेशनल लॉ। आफ्टर एस्टेब्लिशमेंट ऑफ यूनाइटेड नेशन ऑर्गेनाइजेशन, individual got importance in international law. That Charter of United Nation by using the words people of the United Nation, आपने देखा होगा चार्टर में ये वर्ड लिखा है we the people of United Nation। people, वर्ड people शो करता है कि इंडिविजुअल को यहाँ कितनी इंपॉर्टेंस दी गई है। As the individuals are the subject matter of international law, they are enjoying certain rights, but more obligation। राइट्स कुछ ही हैं, ऑब्लिगेशन बहुत ज्यादा है। लेट अस डिस्कस अबाउट द राइट। ह्यूमन राइट, नेक्स्ट इज राइट टू मेक पटिशन। पहले इसको डिस्कस कर लेते हैं। ह्यूमन राइट क्या है? वन ऑफ द प्रिंसिपल ऑफ यूनाइटेड नेशन, अगर आपने प्रीएम्बल पढ़ा हो तो उसमें एम में क्लियर लिखा हुआ है, टू प्रमोट एंड एनकरेज द रिस्पेक्ट फॉर द ह्यूमन राइट एंड फंडामेंटल फ्रीडम फॉर। तो प्रीएम्बल में क्लियर कट लिखा हुआ है कि यूएनओ का मेन पर्पस है टू प्रमोट द एनकरेज द रिस्पेक्ट फॉर द ह्यूमन राइट, ह्यूमन राइट के लिए रिस्पेक्ट क्रिएट करना। एंड यूडीएचआर, जिसको हम फुल फॉर्म में बोलते हैं द यूनिवर्सल डिक्लेरेशन ऑफ ह्यूमन राइट, was adopted by General Assembly in 1948, and two other conventions. The number 1 is the International Convention of Civil and Political Rights, and the International Convention of Economic, Social and Cultural Rights, adopted in 1966. And these provides that various right to the individual, and one more convention is there, that Convention of Elimination of all form of discrimination against the women, and the General Assembly adopted this on December 18, 1979, which provide the right to the women's. Next right है हमारा right to make petition. The rise of the human right has given rise to individual the right to make the petition. जब human rights मिले तो अगर उस राइट का वायलेशन होता है तो पर्सन को राइट दिया गया है दैट ही और शी कैन फाइल द पिटीशन if their rights are violated. Example, we can say that optional protocol to the Convention on Civil and Political Rights 1966 provide for the petition by individual before the Human Rights Committee against own state. अगर कोई भी स्टेट अपने सिटीजन का ह्यूमन राइट वायलेट करते हैं तो सीधा ह्यूमन राइट कमेटी के आगे पिटीशन मूव की जा सकती है। In addition to international convention, Some regional conventions have also provided for the petition mechanism, and the other right is right to conciliation and arbitration proceeding. The Convention for Settlement of International Disputes between the state and the nation of the other states concluded on March 18, 1965. 1965 में कन्वेंशन हुई थी कि शांतिपूर्ण ढंग से अगर ये सेटलमेंट करना चाहे तो एक आर्बिट्रेटर बिठा के अपना सेटिंग कर सकते हैं, so that private foreign investors might have direct access there to settle dispute with the investment receiving states. And these are about the right which is provided to conferred upon the individual. Now, as you know, where there's a right, there's also duties. So duties are individual. International law has imposed direct responsibility upon the individual for the offense committed by him. First is piracy. And you know that under international law, pirates are treated as the enemy of the mankind. Pirates क्या होते हैं? अगर मैं pirates जैसे कुछ डाकुओं का समूह है जो समुद्र में जाते हुए जहाज को लूट लेता है. फॉर एग्जाम्पल आपको मैं बताऊं कि आपने फिल्म देखी होगी हिंदुस्तान का ठग. उसमें जो दूसरी कंट्री से रिलेटेड जहाज होते हैं उनको लूट लेते हैं लोगों को अच्छी तरह वहां पर. तो वो एक ऑफेंस है, ऑफेंस ऑफ पायरेसी है अंडर इंटरनेशनल. So every state entitled, and क्योंकि ये offense है, therefore every state is entitled to apprehend them and punish them. Thus it is the obligation of each and every individual that not to pirate, not to commit the offense of piracy, I would like to say. Next, violation of rule of warfare. Individual member of armed force of belligerent states are criminally liable for violation of the rules of warfare and may be given punishment by the another belligerent. अगर हम warfare के कोई भी rules का violation करेंगे तो we can be punished. In some case, sanction is imposed. Punishment की form क्या होती है? Sanction लगा दी जाती है upon the individual committing the offense by the state having the custody of them by the exercise of domestic jurisdiction, and in few cases by the international procedure. Next है नेक्स्ट ऑफेंस ऑफ एस्पोनेज. एस्पोनेज होता है जैसे जासूस बोल सकते हो आप, स्पाइस बोल सकते हो. Espionage is a crime under the international law, hence when the spies are apprehended they may be punished. Next is crime with दो collectively आ गए. First I am discussing about the crime of genocide. Genocide आपको पता है कि large scale में women को जो मारा जाता है, that is called the genocide. Genocide for which the perpetrator, whether they are statesman, public official, either it may be private individual, this is such type of person is punishable, and this rule was made by the General Assembly in the resolution adopted on December 11, 1946. Next is aircraft hijacking. It's also an offense. Also offense at the international level, and for unlawful and act committed against the safety of the civil aviation. Next duty on the individual is ये नेगेटिव में आपको लिखना है, not to do kidnapping of diplomat person and other person. ये ड्यूटी है क्योंकि किडनैपिंग और diplomat person or other person, we have a convention on the prevention and punishment of the crime against the internationally protected person, including the diplomat agent of 1973 and the Convention of Taking Hostage of 1979, having expressly laid down for the punishment to the individual for the act mentioned in the above convention. Next है apartheid. Apartheid. Apartheid, it is the name of a offense, official name given by the South Africa to its racial policy. रंगभेद की नीति आपने सुना होगा, रंगभेद की नीति को apartheid बोला जाता है, official name apartheid है. The policy violate the law of human rights. The policy violates the law of human rights, genocide, slavery, and it is a crime against the humanity. In order to suppress it and to give the punishment, a convention was adopted by the General Assembly on November 30, 1973. So, in conclusion, I would like to say that no doubt individuals have the important place in international law. If the states, by imposing limitation upon themselves, have agreed to provide a number of rights to individual, there is no reason to prevent the individual from providing the remedies in those cases where their right is violated. On the other hand, there a lot of duty imposed by the international law on the individual, and individual must perform their duties honestly. So that's all about this. Thank you. If you have any query, that is most welcome. Thank you. Thank you all.